of the 204th District Court of Dallas County, cause number F1800737. This is an appeal from the judgment and sentence entered on October 2nd, 2019, in which my client, Amber Guyger, was convicted of murder under Texas Penal Code Section 19.02 B1 and B2. She was convicted as charged in the indictment, and the indictment recited and tracked Section Penal Code Sections 19.02 B1 and B2. In the appeal, I raised two issues for appellate review. In the first issue, I raised a legal sufficiency argument, arguing that my client is not guilty of murder under either 19.02 B1 and B2. And the second issue, I argued that as a lesser included offense of murder, if the court is inclined to not acquit her outright, they have the option under the facts and the law that I stated in my brief of criminally negligent homicide, and with a remand to the trial court for a punishment hearing. Now, Your Honors, this case—
Molly, can I interrupt you here before
Yes.
you get here? I realize you have your two issues, but it would help me if you could address the state's cross issue on jury charge error first before you begin on your issues. I realize there wasn't very much addressed on that in the reply brief, so I'd rather you start with that, please.
I will, Your Honor. The jury charge issue, I raised it. I talked about it briefly in my opening brief. I did address it in my reply brief. In a legal sufficiency case, as the court knows, the issue is whether a defendant is guilty under the hypothetically correct jury charge. And under the hypothetical jury charge, I believe my client was entitled to a mistaken fact instruction. Under Hamill versus State, which is a 1996 Court of Criminal Appeals case, a defendant is entitled to an instruction on any defensive theory, including mistake of fact, if the issue is raised by the evidence, whether the evidence is strong, weak, unimpeached, or contradicted, and regardless of what the trial court may think about the credibility of the evidence. Now, the trial court in this case did allow the mistake of fact instruction. And I believe Grainger versus State, which is a 1999 Court of Criminal Appeals case, addresses it thoroughly. In Grainger, the defendant, there's a Dallas County case, the defendant, one night when he was out, he shot into a vehicle that he thought was empty. Turns out there was a 72-year-old Vietnam veteran asleep in the vehicle without Grainger knowing about it. Now, Grainger was an issue regarding the jury charge, but since the state raised the issue as a cross issue, the Court of Criminal Appeals determined that Grainger was entitled to a mistaken fact instruction because he did not know that the victim was in the vehicle when he fired into it. Now, what Mr. Grainger did was facially illegal. You cannot, under any circumstances, fire into a vehicle, whether you believe there's someone in it or not. However, although he couldn't justify shooting into the vehicle, he could not be guilty of murdering its occupant if he reasonably believed that the car was empty, meaning had no occupants. In other words—
That's because murder is a result-oriented offense, and you kind of are overlooking that.
I don't think I'm overlooking it, Your Honor. It is a result-oriented offense, but the result in Grainger still was that he killed someone. And the result in Ms. Guyger's case is she killed someone. The question is, was there a defense available in Grainger? Is there a defense available in this case? And I think in both cases, it's clear that the statutory defense under Texas Penal Code Section 8.02A that addresses issue 1 is available to Ms. Guyger. Because if you look at what happened in Grainger, for instance, and compare it to what happened in this case, if Ms. Guyger had walked into, knowingly or intentionally, shot and killed a person, in this case, it was Mr. Botham Jean, a horrific result, no doubt. But if she had intentionally knowingly killed someone by intentionally knowingly walking into her apartment, she'd be guilty of murder. But if there was a mistaken fact, a reasonable belief of mistaken fact, which I assert she had, because I think the evidence shows that she thought she was walking into her own apartment. Just like in Granger, the defendant did not believe that there was anyone in the car. That's the type of mistake of fact that I believe Section 8.02 contemplates as set forth by the Texas legislature. Because in this case, if there's no mistake of fact, defense available, then there cannot be any justification for Ms. Guyger's actions. And she would be guilty of walking into another man's apartment and shooting that man, which is what happened here. However, you have to consider all the circumstances surrounding what happened. Now, just like in Granger, there was some discussion regarding the circumstances surrounding, what had happened. Again, Mr. Granger did not know that there was no one inside the vehicle. Here, all the facts leading up to from the point that Miss Guyger entered the apartment, and that was laid out in the trial, how she was able to enter the apartment, how she is able to access an apartment that doesn't belong to her, the problems that Ranger Armstrong discussed that was with the strike plate on the deadbolt. It turns out that Mr. Jean's door wasn't even locked properly.
Mr. Mola, you're overlooking the fact that Ms. Guyger testified that she intentionally shot Mr. Jean.
I'm not overlooking the fact, Your Honor. I agree she did intentionally shoot Mr. Jean because that was her intent. That was the truth. Okay, those were the facts of the case. If she had walked into her apartment and there was an intruder inside her apartment under Section 9.32A and Broughton, as I laid out in my brief, she would have been entitled to use deadly force in self-defense. Okay.
Well, you cite the Broughton case, but if you read the Broughton case, the defendant or the appellant in that case was mistaken about some facts, but not mistaken in fact, mistaken about some of the facts related to the self-defense claim. The defendant in that case testified that he thought the about-to-be decedent was reaching into a motorcycle side bag for a weapon and shot him, and the jury rejected that self-defense claim, which seems awfully similar to the jury's rejection of your client's self-defense claim here.
Your Honor, the self-defense, again, but the problem with what happened in Broughton is that the self-defense claim there was different than the self-defense claim here. My client, according to the facts, had a reasonable apprehension of danger when she walked into what she thought was her apartment. Now, again, if we agree that she thought she walked into her apartment, then the mistake of fact instruction applies. And then the question is, was her belief, was her apprehension of the danger reasonable? Now, the case law is very clear that I set forth in my brief and the reply brief that, she doesn't have to be in actual danger, only apparent danger. Was that apparent danger reasonable? Okay. Now, the evidence presented during the trial showed that many other people inadvertently walked to the wrong floor of the Southside Flat apartments. They walked to the wrong, or they drove to the wrong level of the garage of the Southside Flats apartments. They walked to the wrong door. One witness who, this wasn't like some man off the street. This witness was an attorney here in Dallas that works for a civil firm. He testified that one time he walked into the wrong apartment and didn't realize he was in the wrong apartment until he saw a lady sitting on the couch looking at him with amazement. So again, the issue is, if the court believes that her mistaken fact in going to apartment 1478, which is one floor above hers, the same side, same part of the building, was reasonable, then the mistake of fact instruction applies.
Mr. Mola, would you address the case cited by the state in their brief, Solis v. State, a Texas Court of Criminal Appeals case, which is our precedent, talking about the when you're entitled to that instruction on mistake of fact that the kind of culpability is meant culpable mental state, which in this case is the intent to kill. In other words, there has to be evidence negating the intent to kill. Would you address our precedent in the Solis v. State case?
1 second here.
416 Southwest 3rd, 419, Texas Court of Criminal Appeals, 2013.
Yes, Your Honor. Your Honor, the issue is, as discussed in Solis, that there's other precedent that I address that I think is more applicable in this case. But in discussing Solis, there was an intent to kill on Ms. Guyger's part. She testified to it. Okay. The problem is, I think for the state's argument is that, again, if she had been in her own apartment, does the court believe that she would have had justification to shoot to kill? Okay. This is not a case, of where she emptied her magazine. There was a lot of stuff in the media about that. She fired 2 shots after she said, "Let me see your hands," twice. She walked in, she saw a dark shadow in the back. There was very little lighting. She said, "Let me see your hands, let me see your hands," twice. Joshua Brown testified, the witness that lived across the hallway, that he heard loud voices of 2 people that sounded surprised to see each other. Okay. So again, yes, she intended to pull the trigger. Yes, she intended to kill who she thought was an intruder in her home. Now, I'm not understating the fact that these facts have never happened before in Texas. Okay. There's never been a situation where a person that I know of in Texas walked into the wrong home, reasonably or unreasonably, and shot someone inside the home. That's never happened in Texas. So I acknowledge that she intended to kill because that's what she testified. The question is, and her getting to that point, when she walked into the wrong apartment because of the perfect storm, as Ranger Armstrong described, going to the wrong floor, walking down the wrong hall, coming to the wrong door, missing the clues of the vase that should have been there, missing the clue of the half moon red floor mat, missing the clue of the fact that, she was at apartment 1478, not 1378, which was the sign that was way up to her left. If she missed all those clues, was her entering the apartment believing that it was hers a reasonable set of facts that would allow application of section 8.02A? And I think that's a question for the court. And again, I acknowledge that she intended to kill. That's, I never stated in my brief that she didn't intend to kill. But the fact of the matter is, if she had picked up on any of those clues, however minor, despite the fact that many other people in the apartment building missed those clues when they were walking, although I acknowledge that, they didn't shoot anyone inside the apartment, understand that, she was a police officer. Okay. And, there's a police officer that testified during the trial that when you come upon a scene like she did, if it was a burglary call, then you would cover and conceal and wait for backup. But that same officer testified that if he had come upon his own home and he thought there was an intruder inside, he would go inside and go after the intruder. Okay, now,
Mr. Mola, aren't you erroneously mixing mistake of fact, defense, and self-defense justification? Those are in under two different titles in our Texas Penal Code. Mistake of fact is a defense, and self-defense is a justification. So doesn't the fact that she testified that she believed she was in her own apartment just go to whether or not she had a reasonable belief that she was in such immediate danger that she had to use deadly force? In other words, go to her to self-defense. So aren't you mixing those two?
Your Honor, I'm not mixing the two because I think the only way that what happened would make sense if you apply section 8.02A to what happened. 8.02A on its face, it's a defense to prosecution that the actor through mistake formed a reasonable belief about a matter of fact if her mistaken belief negated the kind of culpability required for commission of the offense. Okay, she was convicted of intentionally or knowingly killing another human. Okay, intentionally or knowingly killing another human is an evil act. Okay, that's what she was convicted of. The problem is that when she entered what she thought was her own apartment, she did not have evil intent when she entered her own apartment. Merely, again.
Just because of her alleged mistaken belief about where she was doesn't negate her intent to kill.
But Your Honor, it negates, my argument is it negates the mens rea, it negates the evil intent. Okay, because we wouldn't be here talking about this if she had walked into her own apartment. Okay, so she walks in her own apartment and she shoots and kills an intruder. Okay, here she walked into the wrong apartment, and in these horrific set of facts, she shot and killed Mr. Jean. The only difference between those two scenarios is her mistaken belief about where she was. Was that mistaken belief reasonable under the circumstances? Okay, now, there are many, many cases from the Court of Criminal Appeals that say that mental culpability has to be inferred from the circumstances under which an act based on a defendant's words, acts, and conduct. Okay, I don't think you can reasonably or anyone can reasonably state that when you consider all the facts of the case, when you consider what happened, okay, that she had an evil intent when she walked into what she thought was her own apartment.
Mr. Mulla, you're nearing the end of your time, and I know we need to get to your second issue concerning the lesser included criminally negligent homicide.
Yes, Your Honor.
Why do you think that you are entitled to that?
Your Honor, a criminal negligent homicide under section 19.05 of the Texas Penal Code and section 6.03D talks about inattentive risk creation or the failure to perceive a risk. Okay. As I explained in my brief in detail, I believe that Ms. Guyger at most is guilty of criminally negligent homicide because the evidence shows beyond a reasonable doubt, if the court were inclined to go this route, that she shot Mr. Jean, causing his death. That's undisputed. That she should have been aware that there was substantial unjustifiable risk of death from her conduct because she did not pay close attention or close enough attention to her surroundings and missed the clues of the vase, the red doormat, and the apartment number being off one digit. And the third is,
excuse me, Mr. Mulla, what evidence do we have in our record that shows that if she is guilty, she is only guilty of the lesser included criminally negligent homicide?
Well, Your Honor, in my brief, I went through 47 or 48 factual points, 48 distinct factual points. I start on page 82 of my brief and go through page 99, pointing that what occurred was a clear mistake of fact, and she acted reasonably under the circumstances. Look, Your Honor, she missed basically 4 clues about where she was. Okay, if the question is, she should have been more attentive, and that was some of the state's argument during closing, that she should have been paying better attention to where she was. Okay, so that constitutes a failure to perceive the risk of her actions. That's why I believe that criminal negligent homicide is a viable option for the court as a lesser included offense. She should have been paying more attention. The bottom line is she was convicted of walking into the wrong apartment and killing the occupant of that apartment.
Thank you, Mr. Mola.
Thank you.
All right, if you mute yourself, please, there, Mr. Mola. And Mr. Gladden, you have 20 minutes and you may begin when you're ready, sir.
Thank you. May it please the court. My name is Doug Gladden and I represent the state of Texas. This is a murder case, not a criminal trespass case. When Amber Guyger shot Botham Jean, she didn't take someone else's property. She took the life of a human being. She took Allison and Bertram's son. She took Brant and Alyssa's brother. She took Alexis Stossel's friend. She took Joshua Brown's neighbor. She didn't make a mistake about that. She knew Botham was a living human being. She pointed a gun at him. She intended to kill him. That's murder. It's not negligent. It's not mistake of fact. It's not justified. Amber Guyger murdered Botham Jean. This court should say so and affirm the trial court's judgment. Now, this appeal is about the sufficiency of the evidence, so we have to look at the standard of review. And the standard of review is that evidence is legally sufficient when viewed in the light most favorable to the verdict. Any rational trier of fact could find all of the essential elements of the offense beyond a reasonable doubt, and could find against the defendant on any defensive issue beyond a reasonable doubt. Now, that standard matters here for two reasons. First, this court has to decide what defensive issues were raised by the evidence in the first place. And then the question is not whether the jury could find for appellant on a defensive issue, it's whether any rational jury could find against her. So starting with the first, mistake of fact was not raised by the evidence in this case. Now, in the briefing and here in argument, appellant says that this case is about mistake of fact, but it's not. Mistake of fact is different from other defensive issues. Most defenses say, yes, I committed the offense, but it was justified, or it was necessary, or I was under duress. Mistake of fact is different. It says, I didn't commit the offense because due to a mistaken belief, I did not have the culpable mental state. Now, culpable mental states are intent, knowledge, recklessness, or criminal negligence, and they have to apply to the result of the conduct, the nature of the conduct, or the circumstances surrounding the conduct. For murder, the mental state relates to the result of the conduct. That is, you have to intend to cause death or serious bodily injury. Now, appellant is saying that her mistaken belief related to her reasonable belief that deadly force was necessary, but reasonable belief is not a culpable mental state. It's a term that's used in the penal code as a part of defensive issues and affirmative defenses. Specifically, in this case, self-defense requires you to have a reasonable belief that deadly force was immediately necessary. That's not a culpable mental state. It's simply a defensive issue. There was no evidence in this case of any mistaken belief on appellant's part that would negate her intent to kill Botham Jean. She never testified that she believed Botham was an animal, like a bear or a dog. She didn't testify that she believed her gun was unloaded or that she had a taser instead of a gun. She didn't believe the apartment was empty or that Botham was wearing body armor or that she was shooting blanks or that she was aiming away from Botham. All she said was that she believed she was in her own apartment, and that doesn't negate her intent to kill. So this court has to decide whether mistake of fact was raised by the evidence in this case. This court has the responsibility to apply the correct law and do so correctly. Now, this is the state's cross issue, and we're not asking for an advisory opinion on this. Whether mistake of fact was raised by the evidence in this case is a legal question, and the state will benefit from it here because the question on the appeal is whether the legal sufficiency analysis should look at the mistake of fact defense at all. Now, in the reply brief, appellant says this court has no jurisdiction on this because under Sagel-Mabel, the state is asking this court to review an alleged jury charge error to provide guidance and prevent errors in the future. No. In Sagel-Mabel, the instruction was on an evidentiary issue, specifically whether the defendant's statement was voluntary. That's not an element of the offense, and it's not a defensive issue. And the appellant in that case didn't raise anything related to the instruction on appeal. Here, appellant is challenging the sufficiency of the evidence, and she's arguing mistake of fact. Whether mistake of fact was raised by the evidence then is what this appeal is all about. Now, appellant says that the court can deal with this issue simply by deciding whether the jury erred in finding against her on her defensive issue. But this court can't deal with the issue that way. To do that, this court would have to say that mistake of fact was a defensive issue that was part of the hypothetically correct jury charge. But mistake of fact wasn't raised by the evidence. Since it wasn't raised by the evidence, this court cannot write an opinion that both sets out a hypothetically correct mistake of fact instruction and correctly applies the law in this case. This court would be left doing what the trial court did, which is applying the wrong law and doing so badly, and saying that if the appellant reasonably believed that she was in her own apartment, then the jury would have had to acquit her, even if the jury found that she committed murder and that it wasn't justified. And that's not the law. So that leaves self-defense as the only defensive issue raised by the evidence. And the standard of review matters for that, because the question is whether any jury could have rejected appellant's self-defense claim. The only evidence of self-defense in this case came from appellant's testimony. She said that she believed Botham was in her apartment, that she commanded him to show his hands and he didn't, and that he quickly moved toward her while saying, "Hey, hey." But the jury can disbelieve any or all of a witness's testimony. And if the jury didn't believe appellant's testimony, then there's no other evidence of self-defense, much less insufficient to reject self-defense. And all the other evidence in the case contradicted appellant's testimony. No one heard her give commands to show hands. Botham didn't have pockets where he could have hidden his hands. The trajectory of the gunshot wound means that he wasn't quickly moving toward her. And no reasonable person would have mistaken Botham's apartment with the red doormat, the backlit room number, the flashing red light on the lock, and the marijuana smell as her own. So then there are the elements of the offense that the state had to prove beyond a reasonable doubt. That appellant intentionally caused the death of an individual. Appellant admitted that she was the shooter, and the bullet in Botham's body came from her gun. She intentionally did it. She admitted that she intended to kill Botham. She shot center mass. She shot him with a firearm, which is a deadly weapon. She shot at a downward angle, and she didn't render first aid. She caused his death. He died of a gunshot wound. The gunshot came from his gun. And Botham was an individual. His sister testified that he was a human being who was alive. She spoke to him that same day, and he was excited about eating ice cream. The evidence in this case is sufficient to prove the elements of murder and to reject appellant's self-defense claim, and mistake of fact was not raised by the evidence in this case. I would ask that this court affirm the judgment of conviction. Does the court have any questions?
Do you have any, I'll have to go back and reread your brief, but was there any particular cases that you cited to, assuming the court wants to sustain your cross issue, anything in particular that you wanted the court to address, or any precedent that you think is most appropriate to apply?
The most appropriate precedent to apply is, I believe it's pronounced Pfeiffer v. State, that says this court can appropriately address a cross issue if the state would benefit from it on the resolution of the appeal. And the reason why the state benefits here is that this court has to decide whether mistake of fact was even part of the hypothetically correct jury charge that this court is going to analyze the sufficiency of the evidence on.
I guess what I'm kind of asking is, Mr. Mola mentioned in his argument that he couldn't find any particular case kind of on point factually. Are there any cases that you know, like the Broughton case that he cited in his reply brief, I thought was actually on point for you, Mr. Gladden, or for the state. Are there any other cases that talk about mistake of fact not being appropriate? A mistake of fact regarding the reasonableness of the use of force, but not a legal mistake in fact.
Yes, Chief Justice Burns. I'm sorry, I misunderstood your question. There's a line of cases that talk about that. Broughton is the primary one. We have the lower court opinion that specifically says that a mistaken claim raises self-defense rather than mistake of fact. In the supplemental letter brief that I submitted to the court, there's 2 additional cases. One is from the 14th Court of Appeals, Rocha v. State, and then the other is from the Fort Worth Court of Appeals, Maupin v. State. And both of those cases recognize the same thing, that a person who claims that a mistaken belief about the reasonableness of their conduct is not a mistake of fact when you're talking about a result-oriented offense. It simply raises a defensive issue, whether you're talking about self-defense or defensive property. And then I guess what you would call the big case that supports all of this intellectually as an underpinning doctrine is Shaw, because Shaw makes it very clear that when you're talking about a justification defense, like self-defense, Shaw was talking about I believe necessity, but either one, you're talking about necessity, justification, or self-defense, deadly force and self-defense, defense of property. Those are justifications under Chapter 9. And Chapter 9 says that it's a defense to prosecution that the conduct was justified. And what Shaw points out is that conduct means an act and the culpable mental state. So if you're claiming a mistaken belief that negates the culpable mental state, you don't have criminal conduct to justify under Chapter 9. And that's why, as Justice Meyer said earlier, these are in different chapters of the Penal Code. These are separate defensive issues, and you can't shoehorn mistake of fact into a justification claim.
Thank you.
Mr. Glenn, I have just one comment.
Yes.
Thank you very much for an excellent written brief. It was very pleasing on the eye. As a matter of fact, I had my attorney look up what font you used because I liked it so much during late nights. That's appreciated. So thank you very much for the written brief and the letter brief, the letter as well.
You're welcome. And thank you, Justice Partita Kipnis.
All right, any other questions or? All right. Well, thank you, Mr. Gladden. Oh, sorry.
Thank you.
Thank you. Thank you. All right, Mr. Mola, come on back. There you go, sir. All right. And Mr. Mola, you have 5 minutes for rebuttal and you may begin. Mr. Mola, I think you're still muted.
Can you hear me?
Yes, sir. Gotcha.
I have nothing further, Your Honor.
Okay. All right, then. Oops. Now I'm having there we go. Now I'm having a technical problem here. All right, then. I guess we're done then, and I'll thank both sides for excellent briefs and an excellent presentation today. We will be in recess in this matter, and we'll take the case under advisement, and we will issue our opinion in due course. The case is submitted. Thank you. We're in recess.
Thank you both very much.
Thank you both for excellent arguments. Thank you.
Because of our background, us being refugees.
Since she was a little girl,
She had an immense sense of justice. Tali believes in fairness and the safety of every single person.
Tali Farhadian Weinstein for District Attorney.
Dallas police arrested former Lieutenant Governor David Dewhurst, charging him for attacking his girlfriend.
Police say video footage shows him shoving her. It happened outside of a hotel room. Fox 4's David Santendry live with details about the arrest. David.
Heather and Steve, the girlfriend of the former lieutenant governor, just had charges against her dropped last week. Now he's the one facing a criminal investigation. Former Texas Lieutenant Governor David Dewhurst is charged with assault. Dallas police arrested the 75-year-old for allegedly pushing his girlfriend, Leslie Karen, down on the ground outside the DoubleTree Hotel near Lovefield.